Good evening, everybody. Good evening. Good evening. Hello, 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 hello. Hi, everyone. I just hope you guys are having a wonderful evening. Again, we are here for another episode of the Cardi B versus Tasha K defamation slander trial. We will be reading the transcript. Again, we have our wonderful Dr. Blake, who did an excellent job yesterday, as well as our regular actors. Just give us a few moments as we get the folks on in. I'm still waiting for some people to come on in. I'm going to play some music for you guys. Just give me a moment, okay?
Kelly likes me. You figure this is wrong, right? First case, Rob got indicted. We got arrested. Stuff going on.
Okay, ladies and gentlemen, I am so sorry for the delay, but we are ready now. We are ready. We are ready. And we're going to start from page 52, guys, okay? We're going to start from line number 4, okay? All right, let's get started, everybody. Again, I would like to introduce you to my cast. First, we're going to have our own, myself. I will be the court reporter. Hello, everybody. And next, we will have our own judge, played by Mel. Hello, Mel.
Hi.
Hi. And as for our uh, Cardi's attorney, will be played by our own Purple Couch, Miss Moore.
Howdy, howdy.
Take your thing is up. And we have a new player to this evening for playing Olga. I'm no longer Olga and was being played by Perspective Me. Hello, Perspective.
Hello.
Hello. Okay, Mel, I think you need to turn your background down. All right, again, here is our doctor, the famous and celebrity on this staff here is Dr. Sherry, played by Ilana. Hello, hello, hello.
Hello, everyone.
Hi. Okay, guys. Sorry for the delay. We are going to get started. All right, everybody. Everybody ready?
Yes, indeed.
Yeah.
All right. All rise. Upon entering, the jury enters the courtroom. Please be seated. Come to order.
All right. So before we broke, the defendant had showed, is it Exhibit 99?
You know what? I'm sorry. I have to apologize. You said page 4?
No,
52,
page
line
52.
4.
52, line 4.
52. I'm sorry.
That's okay.
52, line 4. Okay. So, yes, Your Honor.
Okay, so go ahead.
I'm not sure. Not yet, Your Honor.
Line 17.
Oh, okay. Miss Blake. Miss Blake, if you would like look at your screen and let me know if if you're familiar with the document that's on the screen.
Yes,
And could you tell us what that is?
it was a summary.
I'm sorry? Can you give a little more detail about it? What kind of summary?
Is that a summary you prepared, ma'am?
Sorry, yes, I couldn't hear.
I'm sorry. Thank you, Judge. So this was a summary that you prepared after some sessions with the plaintiff?
Yes,
And at this time, I would move Defendant's Exhibit 99 into evidence, Your Honor.
No objection?
No objection, Your Honor.
All right, 99 is admitted.
Defendant's Exhibit 99 was marked for purpose of identification and admitted into evidence.
And let me ask you a couple of questions about the document itself. You have already testified that you went to New York at the beginning of November of 2018. Is that correct?
2018, correct.
And this summary is about these sessions that you had in New York. Is that correct?
Correct.
The date of the summary, if you can see at the top, is dated October 26, 2020. Is that correct?
Correct.
So that was about almost 2 years after the actual session had occurred.
Correct.
And then in the second paragraph on this page, towards the bottom of the second paragraph, you specifically noted Ms. Almazar denied any suicidal or homicidal ideation. Is that correct?
Correct.
And then if we could go to the second page of the same summary, and at the end of the summary, you noted that given psychotherapy was not conducted, a clinical diagnosis was not made. Is that correct?
Correct.
And I believe you testified on direct that during your 2018 sessions, the plaintiff had mentioned or told you that my client was saying that the plaintiff had HPV. Is that correct?
She had mentioned, I'm not sure the exact date, but she had mentioned that she had herpes or reported she had herpes. I'm not sure exactly when that occurred, but by the time I wrote this summary, I was aware of it. And she had reported it.
Okay. I would like to now show you what has been marked as Defendant's Exhibit 103 for identification purposes.
Okay, hold on a second. Now, before we leave that, last question. Can you define who the she was? You said she had mentioned that. She had herpes or reported she had herpes, is what you said, or something like that. Can you use names?
Absolutely.
So that we know we don't have to pronoun reference issues.
Absolutely. Cardi had reported that Tasha K had posted lies and videos regarding that.
Thank you. Again, I'm going to show you what's been marked as Defendant's Exhibit 103 for identification purposes. Do you recognize this document?
Yes.
And can you tell us what it is?
It's another treatment summary.
And did you write that as a result of some other sessions that you had with the plaintiff?
Yes.
Your Honor, at this time, I will move Defendant's Exhibit 103 into evidence.
Document 103 as redacted?
Yes, Your Honor.
Any objection?
No, Your Honor.
All right, 103 is redacted and is admitted.
Thank you.
Defendant Exhibit 103 was marked for purpose of identification and admitted into evidence.
And this was a summary of the session that you testified about that you had in November of 2020. Is that correct?
This is a session I had. This session was
Doc-
both
Doc-
2020
Dr.
and.
Blake, Dr. Blake, you're breaking up.
Okay, I'm sorry. Let's start back. This is a session I had. These sessions were both in 2020 and 2021. This was a summary of that. I reflected back from what had happened in New York and her coming back.
Right. So I think in the first paragraph, I think you summarized the previous, the 2018 sessions, and then you moved into the 2020 sessions. Is that fair to say?
Yes.
And the document itself is dated December 3rd, 2020.
Yes.
Is that correct?
December 3rd, 2020. Yes.
Okay. And I don't know how long ago was the last time that you had read it, but there's no mention in there in this document in the two pages of the plaintiff saying anything about the plaintiffs being suicidal or having suicidal thoughts. If you need to take a moment to read that, just let me know when you're done.
Okay.
Okay. Did you see any mention of the plaintiff being suicidal or having any suicidal thoughts in this document?
So you want me to move to page 2, please?
Sure.
I did not use the term suicidal in this. I talked about her symptoms and what was reported.
So there's no mention about her being suicidal.
No, that was in December 2020.
So just a couple more questions. Both of these summaries you put together are written after the plaintiff had filed this lawsuit. Is that correct?
I'm not sure if the lawsuit was actually filed. The request was made at some point, so I'm not sure of the date and the response.
You're probably going to have to hit the echo cancellation because you're kind of sounding like you're going underwater.
Yeah.
Is it like that now?
Kind of. If you hit the settings little tool, it'll say echo cancellation. Hit that and then wait and then hit it again.
All right, I just did it. Is it better?
We'll see. Okay.
Okay. So I'm not sure if the lawsuit was actually filed. The request was made at some point, so I'm not sure the dates in the sequence.
Okay. If the lawsuit was filed in March of 2019 and both of these summaries is dated was written in 2020, is it fair to say that they were both written after the lawsuit was filed?
Yes.
And you spoke with the plaintiff's attorneys before you came to court today to prepare for your testimony.
Sorry.
You're gonna probably have to try it again because they're saying they can't hear you.
Okay. Let's try
That
it.
was better.
There
Now
you go.
see. Oh, that got worse. Let me do this.
Okay, she's
It was
coming out.
better for a second.
We apologize. Technical difficulties. StreamYard is very, very naughty.
Sensitive.
Sensitive. I was gonna say naughty, but you said sensitive. Okay.
That should work.
Okay.
No.
No, that's
Are you on the
I
headset?
was like aliens.
Are you on the headset?
Oh, what is
Oh,
going on?
ouch. Are you on the headset, Dr. Blake? Okay.
She went off.
We're gonna play some music for you guys while y'all wait.
Okay.
Ow. Do you have something else in the background? Try closing all your tabs with the exception of the of StreamYard. You might have other tabs open. Guys, we apologize. You know how it is. Technical difficult. Green Tech says unplug the mic and then plug it back as well.
Can you hear me now?
Yes, we can. Thank you.
God. Okay. That was just crazy.
Okay, now you
yesterday.
now you're acting up again.
Get out of here.
I'm serious.
Nothing has changed since yesterday. I'm so not understanding this.
Now
It's
we hear you
okay.
better. There you go.
Okay,
There
well,
you
let's
go.
rock and roll.
Okay,
So I'm
let's do it.
sorry.
You got it?
I just said I'm sorry. Line 20.
Okay, I think Olga, you the one who's messing us up now. I can hear stuff in your background.
I don't have anything. Is it? Well, let's see. Is that better?
Much better. All right,
Okay.
guys, let's go.
Okay. Did you speak with the plaintiff's attorneys to prepare for your testimony in court today?
I'm not sure what you mean by
Line 22.
prepare.
Go over
Oh,
your
yeah.
testimony.
No,
You did not.
no. We talked about just making sure, you know, I was familiar with what I had submitted, but not. I don't know what you mean by prepare.
I don't mean that they told you what to say. I mean, did you speak with them about your testimony in general to, jog your memory about some things or, to go over the documents that you've prepared?
No, they did not try to jog my memory.
And you're being compensated by the plaintiff to be here today?
He compensated by the plaintiff, yes.
Your Honor, if I may have one moment.
Sure.
I have no further questions. Dr. Blake, thank you.
Any redirect, Ms. Moore?
Mhm.
Yes, Your Honor, just briefly. Dr. Blake, is it uncommon for people suffering from significant mental health distress to be hesitant about continuing psychotherapy?
Absolutely.
Why is that?
Sometimes they underestimate themselves personally, the severity of it, also because they have schedules. Many times, for most people in general, not just celebrities, mental health is put on the back burner. You do the job, you work, you do everything you need to do, but a lot of time we as people take care of ourselves last. And mental health definitely is put on the back burner.
And when you did your 4 sessions with Cardi in New York in November of 2018, you testified that at that time you did not believe she was suicidal, correct?
Correct.
Based on your opinion, observation of my client, when do you believe she developed suicidal ideations?
She developed suicidal ideations by the time I saw her in 2020. She was extremely stressed and she was overwhelmed. It wasn't, she felt totally helpless. So it was an issue of, well, she was just still upset. When I saw her in New York, she was, she was upset. But this was the beginning to be the tip of the iceberg because at this time in 2020, she didn't have any idea if this was ever going to come to an end.
I think you testified earlier that she expressed a desire to end her life to you. Is that correct?
Yeah.
Would you have put a, well, can you describe what a safety plan is?
Yes, after a risk assessment is done and I look at the factors that may contribute to suicide, there are levels, you know. I didn't feel she needed hospitalization. She didn't make that criteria. However, a safety plan is agreement in terms of if she had any intent in terms of action to commit, she would call me and I didn't care. It was 24/7.
Would you have put a safety plan in place had she not been suicidal?
No.
No further questions, Your Honor.
Court. Court.
Your Honor.
Oh, somebody muted me. Any further questions from the defense?
No, Your Honor.
Okay, may this witness be excused, Ms. Moore? Do you wish to excuse this witness?
Oh, I'm sorry, Your Honor. Yes, I do.
All right, any objection from the defendant for this witness being excused?
No, Your Honor.
All right. Thank you, doctor.
All right.
Oh,
All right. Thank you,
Thank you.
doctor.
doctor.
Miss Blake.
Thank you.
All right. Any other witnesses or evidence from the plaintiff?
No further witnesses, Your Honor. There was one small question about two exhibits. If we could have a moment in a sidebar.
All right.
Sylvia.
Upon a bench conference was held between court and counsel.
Thank you, Your Honor. We just noticed over the weekend in reviewing the transcripts that there were two exhibits we thought were moved in that we didn't have you officially saying as in.
Okay. Which ones?
Plaintiffs 615,
All right. I've marked it in.
okay, and defendants, I believe, is in as well. I just wanted to put something on the record. And then plaintiffs 1011, and they have this one marked in as well.
10 and 11.
No, 1011. Sorry, 1011.
I do not have 10, 11 marked in. An article, picture of an article?
It was one of the photos of the tattoos that we offered into evidence.
Does that describe it?
Yes, screenshot of, sorry, Your Honor. Yes, yes, absolutely.
So you,
Also, I have it marked as it was admitted into evidence as well.
does the defendant have any objection to it being admitted?
No, I don't.
All right. So 10, 11 is admitted.
Reporter.
Sorry, I'm muted. Upon plaintiff exhibit 1011 was marked for a purpose of identification and admitted into evidence.
What I have was that the minutes reflected that 1008 was admitted, but I do not have that marked as admitted.
I do not have 1008.
I didn't have 1008. We had 1007.
You said the minutes. You mean the court's minutes online?
That's what I believe that's what I wrote down.
Yeah. I don't have 10-8 admitted or tendered or necessarily even talked about.
Right. And me neither. So I just wanted to make sure.
Sorry. And I don't believe so either. I think it was 1007, which,
Anything else?
no, thank you, Your Honor.
No, Your Honor.
I appreciate that.
All right. Does the plaintiff want to rest?
We do, Your Honor.
All right. Thank you. Is the defendant ready to proceed with its case?
Yes, we're ready, Your Honor.
All right. You can call your first witness.
Your Honor, the defense calls Miss Latasha K to the stand.
Uh-oh.
All right. Thank you. All right.
Oh, now you gotta be Tasha.
Oh,
Dr. Drake, Dr. Blake, can you be can you be Olga?
Well, am I back to Tasha?
You
Yeah,
back to Tasha. Yeah, you back to
you do her so well.
Let me change my name. All right. Okay.
Oh
So
no, this is back. Doctor, this is back. Dr. Sherry, is she there?
is
Hello?
Sabat doing all the questions?
I think so. I'll do Sabak. Okay, I'll be Sabak. All right, are you ready, guys? Okay. Good morning.
Ooh,
Good morning.
where we go?
what line are you on, girl?
Sylvia, we were on 14 or 15, 16 now. It's court.
Oh, I'm caught too? Oh, Lord Jesus.
No, I'm not. Okay. Thank you. All right. Do you still have your face shield? Do you need another one?
Am I still under oath?
I'm sorry.
Oh,
Are you going to swear me in again?
oh,
Yeah. So I was
What?
going to just mention the
wait,
oath.
wait a minute. Who you talking to like that, lady?
Right.
That is unbelievable.
Oh my God. What
Yeah.
page are we on, y'all? I'm sorry.
21.
Well, I
Yeah.
just
So I was going to just mention the oath that you ascribed to earlier. Still controls your testimony.
Okay.
All right.
oh
Thank
my
you.
Has this been changed?
what?
It has been.
Okay.
Thank you, everyone. Everyone's patient. We appreciate it. Latasha Latrina Kebe. Is that me saying that? Okay. Herein have been duly sworn, was examined and testify as following. Good morning.
Good morning.
State your name for the record, please.
Latasha Transrena Kebe.
Miss Kebe, you're the defendant in this case.
Yes, sir.
All right. I want to first start off by introducing myself to the jury. I'm sorry. It just Why is he introducing himself to the jury? Lord Jesus.
Introducing her to the
But
jury.
she was already on. Okay, sorry.
Stay in character, boo.
Starting off by introducing yourself to the jury, past your name. Let's get to know a little bit about you. Let's start off in 2010. How did you first become interested in, I guess, media, celebrity, gossip news, all that stuff?
I'm sorry. Can you repeat the question? It was kind of low.
Sorry. I want to familiarize the jury with your background a little bit more. So I wanted to start with 2010. When your interest in media first came about? Can you tell the jury about that?
Okay. Well, I was a, you went way back. Okay. 2010. I was a server in Hagerstown, Maryland. I worked at Buffalo Wild Wings as a server, bartender, key manager, and on certain days, Buffalo Wild Wings did a lot of marketing per se to get business into the restaurant, and they used the radio stations. And so whenever they hired radio stations, sometimes the radio station couldn't make it. And so I decided to and pick up the mic and do birthday shout outs. I would let them know how much wings were and things like that, and what specials we had going on, what prizes and stuff we were giving out, things of such. So that's the first time I picked up a mic. And from there, I believe like maybe 2 years into working for Buffalo Wild Wings, because I started around 2009 per se, 2008, 2009. I interned at a radio station in Frederick because Hagerstown really didn't have that many good radio stations. And so I drove like an hour to Frederick, Maryland, and worked the street team and things like that. And I helped. I'm sorry, my mouth is dry. My mouth really is dry.
Let me ask you another question.
Okay.
So let's talk about the radio station. So from Buffalo Wild Wing, the radio station was interested in you. Is that right?
Yes, sir.
Okay. And then you started interning with the radio station in Maryland in about 2011.
I was more so street team. Sorry.
I'm not finished.
Um, I was more so street team. I assisted the radio host in the morning with the prep of the morning show and stuff like that. I did birthday shout outs. I used to sing a lot because I am, you know, I used to sing coming up. So I would do, birthday shout outs and sing happy birthday and things like that.
At some point, did you decide to, I guess, dive deeper into the media career?
Yes, when I first picked up a microphone in front of a stage, in front of a crowd of people, I was addicted. And so, of course, I didn't have the credentials working at Buffalo Wild Wings to host a morning show, you know, FCC regulations and things like that. So I decided to intern. I started for free. Then they started paying me because I was so good, because I did a lot of the in between shifts at Buffalo Wild Wings. I was an hour away in Frederick, set up at somewhere like, I don't know, Wise Markets in the cold snow, doing shout outs, trying to get people coupons and things like that. And so from there, I had a conversation with my husband. It was around like 2011, 2012. I sought out the same radio broadcasting school as Monique, the comedian. And so she had grad school prior. And so when I guess you really went back. Um, when I went to apply, the first day of class, I had found out that they were operating out of a house. I don't know what you call those houses downtown Baltimore. And it wasn't as kept up as, I thought a radio school should be.
Hmm. At some point, do you decide to move down to Atlanta?
Yes. So you know, when I wasn't satisfied with the school that was in Baltimore, I researched the radio market. And so I was between New York, LA, and Atlanta. Atlanta is where I pretty much found my independence because we lived in Atlanta before we moved to Maryland to start our transportation company. And when I moved to, Maryland, of course, changing careers, my husband and I had a conversation. He saw how serious I was about pursuing radio, and he agreed to relocate us back to Maryland, from Maryland to Atlanta. After we figured out LA was too expensive and New York just wasn't the lifestyle for us. And so I'm from the South, from Panama City, Florida. And so we decided on Atlanta.
What did Mr. Keeby do to help further this career, this radio career?
He stayed back in Maryland and worked while me and my daughter drove down and got settled in Atlanta. So he stayed back and worked in Maryland as a restaurant manager for about a year and paid bills in two houses.
Okay.
So that's a
Um,
key.
and you moved to Atlanta with your daughter? Okay, I'm
Yes, she
getting
was
feedback from
6 years.
your I'm getting feedback from your phone.
Me? Okay, let me see
Yeah.
if I could. Better?
Let me talk. Yeah, it's better.
Okay. Yes, she was 6 years old at the time. Yes, sir.
And what did you do when you moved down here beside get an apartment and
Well, first, because I've always been in the restaurant industry, it was easy money. It made it flexible for me to pretty much pursue my career in broadcasting and work, you know, and be a mom full time as well. So I first applied at a lot of radio stations, B103 to be exact. That is my absolute favorite radio station. Frank Ski is my guy, and he said no. So they wanted to give me more so street team, and I was just like,
Miss Keeby? What is street team? Can you explain that, please?
okay, it's a marketing team where you drive around Atlanta, you set up at different business locations, and we broadcast live from on location to let people know to come out and we're here. The radio station is here. We've got coupons, deals of that such. And so that's pretty much what they wanted to do per se.
And at some point, did you start working for the radio station called Love 860?
Yes.
Can you tell us about that?
So after getting turned down by pretty much every radio station, a Christian radio station that Dr. Martin Luther King himself used to broadcast out of, wanted, I'm sorry, Martin Luther King himself used to broadcast out of, wanted a more health driven perspective show
Ah,
for the Christians to listen to in between like Bible segments and things like that. And so they offered me a segment. It was paid. It didn't pay much. It took more money out of my pocket for me to keep it. That show lasted about a year. I got some great experience and yeah. Yeah.
Can I ask you, when you say it costs you more out of your pocket to keep it than to save it, to have it?
Well, because I was working, I was a mom full time. My husband had just relocated from Maryland.
I'm sorry, Miss Kibi. If you would just try to slow down a little bit.
I'm sorry.
Now, I know you're a little nervous.
I'm sorry.
You speak a little fast. Makes sense. You make sense, but you're speaking a little fast.
Okay.
All right. Let me be more specific then. Why would it cost you more money to have this job at the radio station? Why are you spending money?
Because research. Obviously, taking time off work, hiring because we had to pay a lot of guests to come on to talk about health and wellness, such as like, experts that have been in the field for a long time. They don't do it for free per se. And so I had to come out of my pocket hundreds of dollars just to get them onto the show to disseminate information to the listeners that would, help to inspire their health and wellness journey.
Okay, Miss Kibi. Who is Clark Howard?
He was one of my mentors,
Who is Clark Howard?
a consumer expert nationally. Well, former nationally syndicated host. He helped me he helped to mentor me while I had my show as well as Willard Arbor. I'm sorry, Willard Arbor. I always get his name because I called him Will.
Miss Kibi, if you would, I remember 96 rock days from my youth. If you would just explain who Willard Arbor is to the jury.
He is a veteran radio host inducted into the Rock Radio Show Radio Hall of Fame. Willard Arbor hosted 96 Rock for over 30 years here in Atlanta.
All right. And remember when I said slow down?
I'm so sorry. Okay. Let me get some water and I'll slow down. I'm so sorry. I'm so used to talking fast.
Miss Kibi, at some point, you were again dissatisfied with the pace or progress of your career. So in 2014, 2015, what do you start doing?
2014?
Posting video on Facebook or something like that?
Miss
answer.
Maps.
You didn't say yeah or so.
You
Oh,
didn't say
yeah.
yes.
So
Objection, Your Honor.
I went into a deep,
Hold on a second. The objection is leading,
Leading.
and it was. So apparently preliminary, but let's don't make it a habit.
Yes, sir. 2014, 2015.
Okay. So around that time, after I lost the radio show, I couldn't afford to keep it going. I hit a deep depression. And so I went back to, the restaurant full time and wasn't happy. Felt like everything that my husband and I had planned from Maryland to move down here, we had failed pretty much. And so I was taking money out of my pocket. My husband was working. I wasn't working that much. And so I decided, with the advice of my therapist, to go to the internet. He said the world was moving forward. In traditional media, we was told that only rejects go to the internet. So that's kind of what I was just like, no, I'm not going to the internet. Like, I want to move like how Monique moved, or Steve Harvey, or, people like that. But after a year of working with him, I decided to put my first video on the internet with a glass of wine to calm my nerves. And so,
Okay. So please tell us about that video. Where was this video posted?
Facebook, my personal Facebook. I'm sorry. I'm so nervous. I guess having to open up my life like this, I'm so nervous.
Just slow down.
I'll slow down. Okay. I don't get nervous that much, but I'm nervous today. Okay. So when I made that video, I just randomly made that video. I had a glass of wine. I was working at a wine bar at the time, and I saw a reality show with Christina Milian, Lil Wayne. He featured he featured sometimes, but it was more so about her show. She's an R&B artist. And so Lil Wayne had gotten caught with a stripper.
Who is Little Wayne?
I'm sorry. He's a rap artist, and so two high-profile celebrities in the media. And so he had gotten caught cheating, and there was a picture that got posted or leaked to the internet with the girl, the stripper, standing in front of a mirror. So Christina Milian saw the picture. She instantly knew it was Lil Wayne's house, and she called him up on a reality show and said, "We're done." And so I thought that was really inspirational because, a lot of times as women, when we're embarrassed like that, I thought her confidence and not needing her mother's permission or her friend's permission, she saw the picture, she immediately called him and said, this is done. And so I pretty much reiterated that she didn't need anybody. She was confident in herself, and she didn't allow him to continue to disrespect her. And it was, a nationally syndicated show. And so went to sleep, of course, because I was a little tipsy. I woke up, the video had 10 million views. And so that was pretty much my first video in the celebrity gossip arena.
Okay. And then after that, did you stay on Facebook or did you move your platform?
No, I got off of Facebook because my husband worked in corporate America. And after we had and I discussed that I was going to leave radio alone, he came home because some people at work, well, because he, of course, is a manager at a restaurant, had said, you know, did you see your wife on, Facebook and what she had to say? And I guess they showed him a glimpse of the video, and I had on a negligee, but it was covered. I was kind of leaning down so you couldn't see. And he came home, of course, his family is on social media, and he's like, take it down. It's unprofessional. Take it down. And so I took it down and, went into hiding.
Okay. All right. And did you switch platform at some point?
Yes,
What platform?
I had a secret YouTube channel. It was at the time
Why was it secret, Miss Keeby?
because my husband didn't know that I had it. Yeah, he didn't know that I had it. I had named it. It was just under my regular name, Tasha Kibi. It was under the radio show name at the time. It was titled Real Health, Real Beauty. So it was titled under that. I erased the title, put my name, Tasha Kiwi, and started posting videos in about 2016 on YouTube.
What was the first video?
Ray J and Princess. They had, can I elaborate?
No,
I'm sorry.
thank you. Let me ask you this. At what point did Tasha Kibi become Unwind with Tasha K?
I want to say a year after I posted my first video on YouTube.
Around what year?
2016. Yeah, because I posted my first video, yeah, February 2016. So around December-ish of 2016.
Did you come up with the name?
No, my viewers did because I used to drink wine and pretty much comment on celebrity gossip.
Miss Kibi, what was the mission of you Unwind with Tasha K? What do you do?
Well, I take stories from sources that are already on the internet and of course, I investigate the stories and I publish them either as fake news or real news. So that is the mission.
So, is it fair to say that you verify whether or not rumors or news on the internet is true or false? Miss Matt,
Objection, Your Honor, leading.
Sustained. You've just got to ask her what she does. You can't suggest what it might be.
okay, I'll move on. So, you describe two types of, I guess you will verify a video, and two things will happen. Can you describe uh, tell us the two things and describe the two ways you classify those videos?
Okay. So is it better if can I give an example? That's better.
That's fine.
Okay. All right. So
Unrelated.
unrelated. All right. So Black China recently, I did a story on Black China. She's a very controversial Instagram model per se, has a bad reputation, as people would put it, because of her lifestyle that people don't agree with. And so there was a story that was circulating basically stating that she had somehow kidnapped a white woman. And so, of course, social media is a frenzy. Black China has not the great reputation. And I was looking at the video and was like, the video is too short to really classify as kidnapping. And so when I was investigating the source, and a lot of times at the level that I am now, the sources just reach out to me because this is recent. Before, I used to have to go after sources, but this particular source reached out to me. And he was the actual source that uploaded the video of Black China in the hotel room. And the girl comes out crying as if she was like, you know, let free or something. And so, basically said he had a few interviews scheduled with the source and a lot of other big publications, Billboard, Rolling Stone, and he wanted to talk to me because I'm big in the urban area. And I said, no problem. And so when he spoke to me, I had no idea, of course, what his angle was going to be. I was just going to ask him about the video in question that he had posted. And so as we're talking, it was about a 30-minute interview. We had no pre-interview because I typically don't do pre-interviews because that's how you get the most natural reaction and the most real reaction. It keeps them from being prepped per se. And so, when I was speaking to him, he was talking a lot about he had met Black China, at an event. he had some friends that knew her as well, and that she invited them back to the hotel room. And he was with his friends who happened to be a Caucasian girl. And so when they got to the room, some things were going down, and Black China instantly got mad at what he said. So when she got mad, he said that she told him to get out the room, but her friend could stay. And the other friend that they had came with couldn't stay. So of course he's like, "Well, I'm leaving." And so the girl, he was like, "Come on." I think her name was Jennifer. He was like, "Come on, Jennifer, come with me." And so Black China was like, "No, she stays, you go." And so when he left, he said, "Jennifer, you need to come out." And so I guess,
Miss Kiwi, what ended up happening at the end?
I'm sorry. Am I talking too long? Yes,
Okay.
ma'am.
We wouldn't need we wouldn't need all the details, ma'am. Tell us what happened when you interviewed the source. What did you uncover and what did you put out?
Okay. I concluded with the conclusion that he was upset that Black China had embarrassed him in front of his friends and asked him to leave. There was no kidnapping because the girl was in the room all of 3 minutes. And once he asked her to okay, I'm sorry.
Miss Kiwi, just listen to me. You've got to slow down, all right?
Okay. My mouth is dry.
That's fine. You interviewed this source, correct?
Yes.
All right. Tell me what happened. What did you determine? Just tell me what you determined.
Basically
Not why, but what.
that it was a lie.
Thank you. All right. And then what did you put out on it? What did you put a video out? No video on it.
Yes, because there was a police investigation.
All right.
So yes, I put a video out basically stating that it was a lie.
And when you put a video out debunking some rumors, what would you consider that? What would you classify that as? What are you doing?
As pretty much he had created fake news.
No, ma'am. Generally, what you classify that as when you debunk news that's floating out on the internet.
I don't understand your question. Can you rephrase the question? I'm sorry.
Okay. So, I guess my question is, are you talking about fake news? Are you talking about rumors? What are you talking about when you are verifying this example you just gave? Are you talking about fake news?
I'm talking about a story that was circulating as real news, and I classified it as fake news after I spoke to the source.
Okay.
Before I made a conclusion,
So, you debunk fake news? Is that what you're saying?
yes, all the time. Sorry, I'm sorry.
Miss Kibi, when Miss Motts asks you whether or not it's okay to put out fake news, you said yes.
Yes,
Okay. What did you mean by that?
because, there's a lot of fake news going around the internet. And in order to classify it as fake or real, you've got to do your investigation. And so before I put it out, I classify it, after I investigate, talk to sources and publish it. Okay. This was fake news or this was real news. And so, we don't know until people do investigations.
Okay. But when you put it out there, do you classify it as fake news? That's what you're debunking?
Yes, of course. Yes.
All right. So, the purpose of this is to let your viewers know that this information is false out there and you are not to believe it. Is that correct?
That is correct.
All right. So, you're not just simply publishing fake news as though as it is real.
Objection, Your Honor.
No, no, sir.
He's leading the witness.
I'm sorry. I'm sorry. Now, when you hear an objection, if you'll stop, the objection is leading and the objection is sustained. You can't lead your own witness. You've got to ask questions about things.
Have you ever debunked any fake news regarding Miss Almazar?
Yes, sir.
Give me an example.
Without,
One you've heard in court.
I'm sorry.
Give me an example of fake news that you're debunking from what we've heard in court.
Well, am I allowed to answer that question? It would be,
You're not allowed to testify about things that have not been talked about in this courtroom during this trial in front of the jury. Do you have another objection?
I was just waiting until.
So if it hasn't been talked about, the question goes to what you've heard in court while we're engaged in the trial.
okay, I'm sorry.
Miss Keevy, let me ask you this. Was there an accusation you published a fake story as real regarding Miss Almazar, father or a minor?
Oh, that is incorrect. I never published that story.
Can you explain to the jury what you did with that story, please?
Okay. So the story was emailed to me. And so I took a look at the story, of course, Googled Miss Almazar's father, and were able to pull up arrest records. And I found out that it wasn't true. And I published it on my Instagram that it was not covering that story because it was obsolete fake news and it was defaming.
So, you did not publish it as real?
No, sir.
Okay.
No.
Did you classify that story as fake news or on your YouTube channel?
No, sir. Just on my Instagram.
I'm sorry, but you didn't publish it on your YouTube.
No, sir.
Okay.
No, sir.
So, you never classified as real anywhere, only fake.
Yes, that is correct. Yes, sir.
Okay. What is a viral video?
A viral video is a video that typically gets anywhere from 250 to 300 views, 300,000 views on up.
Have you ever had a viral video?
Yes, lots of them. Yes, sir.
The date at issue here is September 19th, 2018. That's the date that the Jones interview was published. Prior to that, had you had any viral video prior to September 19th, 2018?
Oh, yes. Yes, sir.
Any idea how many?
60 plus since I started my channel.
I'm just speaking about prior to September 19th.
Uh, Around, I would say between 50 or 60. It's kind of hard to gauge because I get so many.
Okay. All right. And do you know how many of those viral videos prior to September 19th, 2018 mentioned the plaintiff?
A few, maybe 2 or 3 per se.
And how many videos have you published in total just on YouTube?
Mm, Close to, well, I checked last night. it was like 916.
Uh, you have two of
Oh, I'm sorry. No. Oh, 916.
Do you know how many videos total that you were? Have you ever gotten all your videos on all your videos?
We're almost to 2 million, so that's another big milestone.
Okay, all right. I'm showing you that what's already been admitted in evidence as plaintiff exhibit 834. Do you remember seeing this, Miss Kebby? Kebby?
Yes, sir. I'm sorry, an
Now,
ice cream truck is going by if you guys hear that.
no.
Okay.
Now, these are, do you know what this is?
Mm, It looks like the analytics from either my website or YouTube. They typically look like that.
Okay. Now, I want to focus on September to January of 2019. Did you have any viral videos around this time? This is September 2018 to January 2019. Were there any viral videos that you published?
Yes. Yes, sir.
Which ones?
They were mainly my R. Kelly stories per se.
Okay. When did you publish those about?
I published them from 2017 all the way until 2020. I still publish them, but they had all went viral collectively because a documentary had came out. And
They
so
lies, they lies, I tell you. I'm sorry. 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 Back to you.
okay, back into character. Yeah.
Okay.
And so it pushed the stats per se.
So here's this is September 1st. Was the Jones interview released at this point?
Yes, sir. Around
September 1st. This dot is September 1st. Had the Jones interview been released on September 1st, 2018?
yes, sir. It was released on, I believe, September 18th or 19th, if I'm not mistaken.
Correct. So, this do you
I'm
see
sorry. Doesn't that mean it wasn't released? If he said on September 1st was it released, and she said it was released on 18th and
September 18th?
19th,
Yes, that means it wasn't released.
it
Okay.
wasn't. Okay.
Oh, all right, let me get back in character, y'all. Sorry. Okay. Oh, correct. Correct. So this do you see where I am look at this screen.
Yes, sir.
Is that September 1st?
I believe so. Yes, sir.
So that was before the Jones interview was released?
Yes, sir.
Okay. All right. So the Jones interview did not cause this spike. Miss Mites. Miss Mats.
I'm just talking and I'm unmuted. I'm muted. Okay, objection, Your Honor. He's leading the witness, and she's well. I have one other thing, but I like a sidebar, please.
Yeah, it is leading. Let me tell the jury a little bit about that. So, under Rule 611 of the Federal Rules of Evidence, courts are directed to exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to, particularly, it states in this rule that leading questions should not be used on direct examination except as necessary to develop the witness testimony. Ordinarily, the court should allow leading questions on cross examination or when a party calls a hostile witness, an adverse witness, or a witness identified with an adverse party. So, just to summarize, when a lawyer is asking questions to his or her own witness, normally questions should not be leading. A leading question is a question that suggests the answer in the question itself. I used an example of this in my opening remarks for a version that is, so, Miss Jones, how long have you been beating your wife? That is leading. And in some regards, because it suggests an answer or at least a premise that someone has been beating their wife. If you watch, there used to be a show called The Lawmakers, which was on Channel 8, Channel 30, something like that. But to depending on where you are, maybe a different Georgia public broadcasting station. State legislators are required by rule within the state legislature to ask questions, and they frequently ask questions leading, like, isn't it true, Senator, that X and X is true? Or Senator, it's not true that X and X is true, correct? So those are examples of leading questions. So I'm just telling you, just because we've had a lot of discussion about leading questions, not just today, it's been objection has been made with regard to questions that both sides of lawyers have asked. But just so that you know, understand what the basis is of my rulings. So back to this point at issue specifically. You got to ask open-ended questions to your client. Don't ask leading questions, please.
All right. Okay. Now, Miss Kibi, go back to this graph. How many R. Kelly videos do you believe were released around this time?
I didn't release them. They were already released, and so they had, because of the documentary just came out, the search engine pushed them. And so that's what caused the initial spike. It was really big for our channel around that time.
Okay. I want to show you what we pre-marked as Defendant Exhibit 24. Miss Kibi, are you familiar with this?
Yes.
Without testifying to the content, what is it?
That is a tweet.
And who posted this tweet?
I did.
And is this tweet a fair and accurate representation of the tweet you posted?
Yes, sir.
And is this the correct date that you posted?
Yes, sir.
All right. Your Honor, remove Defendant Exhibit 24 in exhibit.
All right, any objection? Any objection?
Miss Mack.
No, Your Honor. No, Your Honor.
All right, 24 is admitted without objection.
Defendant Exhibit 24 is marked as purpose of identification and admitted into evidence. All right, Miss Wright. All right, Miss Kibi. If you would please slowly read this out for the members of the jury. First, please tell us what date was this posted?
Looks like January 19th. On the 9th of January. Sorry.
Okay. And if you would, ma'am, I would just ask you to please read that out loud for everyone.
PSA winos. Won't he do it? We are definitely viral. All of our R. Kelly content is trending online, radio, and TV. Every one of our exclusives are in the millions. We had 1 million, but now they are tripled, and we are up almost 20 cash subs in 48 hours, bruh. Won't he do it? Numbers don't lie. 7:12 p.m., the 9th of January, 2019.
And so, again, if you would, just for the jury, please read what date does this part cover?
The dates: August, September, October, November, December, January 2019, February 2019. Yeah, 2019.
And from August to January, what year is that?
2019.
Are you sure?
You said from, oh, yeah, 2018, leading into 2019. Sorry.
Thank you. And this again was posted on
January 9th, 2019.
Miss Kibi. Do you recall releasing a video regarding Miss Almazar participating in a Martin Luther King skit, MLK skit?
Yes, sir.
I'm going to show you what's marked as Defendant Exhibit 75. Ms. Kibi, without testifying to the content of that document, do you recognize this?
Yes, sir.
What is it?
It looks like a screenshot from my YouTube channel of the video.
Now, now, what in the world is that? What is that noise? Okay. Now, is this document a fair and accurate representation of a screenshot from your YouTube channel?
Yes. I mean, I can't see the words because they're blurred, but for the most part, yes.
Pardon me.
Yes, sir. That is correct.
Your Honor, defense moved defendant Exhibit 75 into evidence
Any objection?
Yes, Your Honor. Sidebar, please.
upon the bench conference was held between court and counsel.
I just wanted to raise this. Some of these weren't actually on their original pretrial exhibit list, so they've added several new exhibits. So I'm just not sure how we're going to deal with them because at the pretrial conference, right before this trial, Your Honor said you wanted to deal with them while we were on the spot. So I don't know if we should have a conversation about that.
I'm not sure what you're talking about, but just to know, you introduced this many exhibits.
The court reporters will pick you up if you're not a little louder.
Last week, we allowed them to introduce a lot of exhibit. Now that we did receive just a week prior. So I'm not really sure how this.
Other than the contention that this document is not on the pretrial order, is there any other objection?
No, and I think I'm okay with this one. I honestly just wanted to confront the issue because there are several that were problematic that were not originally on their list. And I just figured I would raise it initially. But we're okay with letting this one in, but I don't want to not waive the position. That's all I'm saying.
We cut up the clips that she requested us do in the pretrial order.
That's not what I'm talking about. That's actually not what I'm talking about. I understand that we didn't object on those grounds, and those already came in. I'm talking about there are several things on your exhibit list that were
I can't confirm or deny. I don't know what you're talking about.
okay. Well,
So do you want to fight about this one not being on the pretrial, or you just want to preserve that?
no, I just want to preserve it, and I just wanted to mention it right now. That's all, Your Honor.
All right.
Okay.
Upon the following proceeding continued in open court.
All right. So without waiving any objection to any other exhibit in the future, does the plaintiff have an objection to this document?
No, Your Honor.
And so Exhibit 75 is admitted.
Defendant's Exhibit 75 was marked with for the purpose of identification and admitted into evidence. All right, Miss Kibi, if you would please read the title out for the jurors here. Miss Kibi.
Sorry, I was muted. Cardi B's disrespectful comedy skit mocking Martin Luther King's extramarital affairs.
And can you make the date out?
Yes, yes, sir. September 2nd, 2016.
Is that a 6?
Is it a 6? 18. Yes, 18. Sorry about that.
And was this before or after the Star Marie Jones was published?
This was before.
Okay. All right. I'm showing you what has been already admitted into evidence. Plaintiff Exhibit 532. You recognize this video, Miss Kebby?
Yes, sir.
Okay. Your Honor, I only intend to play the first 6 minutes and 11 seconds. If you want to let us play that, then go to lunch. Up to you. May I proceed?
Yes.
Thank you, sir. And before I play this, excuse me, y'all. And before I play the MLK skit, that was what we heard last week during the plaintiff case in chief.
Yes, sir.
And is this a fuller version? Okay, you're gonna have to mute your stuff while I'm reading, ma'am. Thank you. Is this a fuller version than what we heard last week?
Yes, sir.
Okay. Playing Plaintiff Exhibit 532 from 0 minutes to 6 minutes and 11 seconds. Upon a video recording was played. Miss Kibi, do you go on and discuss Miss Almazar to your recollection after this?
No, sir.
What is cancel culture?
Cancel culture is a group, a society of people who takes pleasure in taking down big name celebrities, politicians per se, over things that they did in their past. So they've succeeded in getting a lot of celebrities and politicians canceled. And so they were in this moment, in this video, coming for Cardi B at the rise of her fame.
Okay. So cancel culture, is that the theme of this video?
Yes,
How is that?
because cancel culture was the one that actually pulled the skit, posted it on Twitter, and basically, was saying that, she had no business disrespecting Martin Luther King, a prominent, figure in our community as Black people that she, took pride in laughing at, you know, the things that I guess maybe he did. But he had reason for doing it. And so they were really basically trying to cancel Cardi B at the height of her career.
Your Honor, objection, sidebar.
Upon a bench conference was held between court and counsel.
The witness is very clearly speculating and talking about what a lot of other people out of court are saying. And she doesn't really have any basis for this knowledge.
Why are we doing this in a sidebar? This is the kind of objection that,
Okay, you
I
may
didn't
have.
want to do a speaking objection in front of the jury, Your Honor. I'm sorry.
okay, well, I mean, objection, speculation, objection, irrelevant. I have yet to figure out the relevance unless it's that she somehow defended Cardi B on occasion. I don't know. What is the relevance of this whole thing? What is the relevance of this whole questioning about? Oh,
Plaintiff was saying that towards her, she is obsessed with her, and she makes her living off of her. It's the theme of their entire case, Your Honor.
well, certainly that's true as it relates to the comments that are sued about, but to the extent that the defendant's position is she has nothing against Cardi B because she has in some aspects defended Cardi B from those who might attack Cardi B, that would be relevant to the issue of whether or not on other occasions when she said what she said about the plaintiff, that she did it with either malice or I don't know what that is. Really, it goes to recklessness or not, but certainly to the malice point.
It's an interest. It's an interesting point because this was someone's.
Okay, y'all got to mute while she's reading.
Okay, you ready? It's an interesting point because this was actually discussed at the pretrial conference, and we've never taken the position that she's never said anything positive about our client. That's not the position we've taken, and I don't see that while we're discussing now a has anything to do with any of the defamatory statements, or B, how she has any actual competency to give the testimony she's given. She's talking about mobs of people on the internet and her under, it's just, it doesn't actually have relevance to the issue.
To the issue of malice?
No, I don't think it does. We've never taken the position that she's never said anything nice. And I guess if they're trying to make that point that she's defending her, maybe it has some limited relevance, but that doesn't overcome the part that she's testifying about what other people think and feel.
Right. But she used the terms in her video. And so he asked her about the term that she used in her video about cancel. I think she used the term cancel culture. But even if she didn't,
Canceling wouldn't.
I don't know. This case isn't, the pretrial order is not the Bible or Quran or of everything. It's relevant to an issue which was malice. And, the jury will have to make their mind up at some point whether they believe, if they decide that the statements made about the plaintiff were not true, whether the defendant did it with malice or with recklessness. Either of those, I guess, potentially could satisfy the plaintiff's burden. But the defendant is entitled to present evidence to the jury that she doesn't have malice towards the plaintiff. And this is one of those examples that they would point to.
Your Honor, like I said, the objection I actually came up here to, though, was competency because what she's talking about, she's very clearly speculating about what other people are thinking and feeling.
Okay. Okay. Those types of objections you're going to have to handle from your chair.
Okay, no problem. I was being careful, Your Honor. Sylvia?
Sylvia.
I'm reading and I'm muted. Lord have mercy. Okay, just for the court's knowledge, I have a couple of follow-up questions. Then I have a 45-minute video.
Okay. So we'll break after your follow-up questions.
Okay, thanks. Upon the following procedure continues open court. Miss Kebe, what is cancel culture?
Why don't we ask it, how does she define cancel culture? How about that?
Miss Kebe.
I guess I was saying before, cancel culture is a group of people online, specifically Twitter per se. They dig up old things that people have done in their past and they use it against them at the height of their career. And they do it to cancel the person's career.
Why did you make this MLK video?
Because cancel culture had gotten know, a response from Cardi B. And basically, she was defending herself against the skit per se. And so I made it in defense of her to say that, listen, just because somebody plays a role, they didn't create the role and they should have canceled the director who happened to be a Black and the writer who hired Cardi B and the other woman to play the roles in which they were hired to do. So she accepted a paid gig per se.
Okay. Your Honor, that's the natural break if Your Honor.
Okay. All right. Ladies and gentlemen, we're going to break for lunch at this point because the next line of the defense presentation involves a very long video. So I don't want you sitting there thinking more about lunch and less about evidence. So we'll break now. Same precautions as last week. Just be careful at lunch. If you're eating outside of the jury room, that you're far away enough from anyone else that you would not unintentionally overhear any discussions about the case. And of course, don't talk about the case. And we'll see you back here. Going to ask if you'll return. We'll say at 25 after. We'll just say 1:30. Just go ahead and say 1:30. We'll see you at 1:30. Thank you.
All rise. Whereupon the juror exited the courtroom.
All right. Anything else we need to talk about before lunch? Nothing from the plaintiff?
Not from the defense. Thank you, Judge.
All right. We'll see y'all at 1:30.
Thank you, sir. Upon recess was taken from 12:18 p.m. until 1:30 p.m.
Right, the court will mark as Court's Exhibit 2 a note from Juror 16 on the original jury inventory list. The note reads as follows: I am familiar with someone mentioned by the defendant, Willard Arbor. He's a friend's father, and I've known him for approximately 30 years. Not sure if that's relevant to the case, but I wanted to be transparent. Thank you. My opinion is that this doesn't really matter that the juror may know a witness. That doesn't mean that the juror is biased. And honestly, it would have to be the lawyer's responsibility, I guess, to find out during their jury voir dire if the juror knew a witness to the extent that matters. So that's my initial belief, is that that I should just tell the juror that I've got her note and that she will continue to serve as a member of the jury without any other elaboration.
Judge?
Yeah, without any other elaboration. Ms. Matz?
It's still you.
Line 25.
It's
That's
still
Miss.
you.
Oh, my bad. Ms. Matz, what does the plaintiff say about that?
Yeah, I mean, I don't think that from this note I see any problem. It doesn't even sound like it's a close relationship. She's just familiar with. So unless there was such a strong relationship, there would be some kind of bias created. I don't see an issue with this.
All right. Anything else from the defendant?
Olga.
No, Your Honor, just this person is not going to be a witness. Just somebody that our client mentioned in passing during her direct.
All right. So I obviously agree with y'all because y'all are agreeing with me. The only implication I might disagree with is that it matters at all at this point, because if she didn't answer a question and she didn't withhold information from us during jury selection, it really doesn't matter. When you think about small town places where everybody knows everybody, and yet, as long as they've said, if asked, that they would be fair, that's all that really matters. At this point, unless she's been dishonest at the beginning, I just don't think it's an issue. So I'm going to deal with it in a very general way. I'm not going to call the juror out by name. Just say, I've got your note. You'll continue to serve, and leave it at that. Okay?
Okay.
Thank you, Your Honor.
All right, Miss Kebe, if you want to come on back up to the witness stand, we can bring the jury in.
Sylvia.
Hold on. Yeah, I got two parts. Okay. Up. All rise. Whereupon the jury enters the courtroom. All rise. Please be seated and come to order.
All right, ladies and gentlemen, one of you sent me a note at lunch about the fact that you might know directly or indirectly one of the individuals whose names was mentioned by the defendant during her testimony this morning, and you wanted us to know that. And I've considered your note along with the advice of counsel, and we don't see any problem with the juror who sent the note. All right, you can proceed, Mr. Sabak.
Thank you, Your Honor. Miss Kebe, welcome back.
Thank you.
We are going to slow down this afternoon, right?
Yes.
Okay. The juror will appreciate it. I want to talk to you about the Joan interview. Do you recall what I'm talking about?
Yes. Star Marie Jones. Yes, sir.
All right. So, can you tell me how you first heard about Star Marie Jones?
I believe it was New York Fashion Week. Cardi B had attacked Nicki Minaj at an event.
And who is Nicki Minaj?
She's another artist such as Cardi B.
Is she one of the on the same level of Cardi B as far as fame and popularity?
Yeah, you could say, yeah. And the story was super viral, and being that it was super viral, us entertainment news reporters, we all go after the story. And so there was many different angles as per se. Everybody was going. And so I came to know Star Marie because Star Marie had uploaded a live stream basically detailing her relationship with Cardi B and basically said that Cardi B had attacked her similar to how she attacked Nicki Minaj at New York Fashion Week. I believe it was like a week or so prior.
One second. Okay. Where did you see Miss Joan make these claims?
It was on Lovely 2002 YouTube channel. It was a live stream that Star Marie had recorded on her Instagram, and Lovely T took the live stream that Star Marie didn't save, and she uploaded it on her YouTube channel, and that's where I saw it.
Okay. Let me stop you. Who is Lovely T or Lovely TI?
She's another entertainment news reporter such as myself.
One second. All right. And when you say Lovely T, what is this? Is this the same person that plaintiff referred to as Lovely TI?
Can you say that again? I'm sorry.
When you say Lovely T, is that the same person that the plaintiff referred to as Lovely TI?
That is correct. Yes, sir.
Okay. Now, you said the first time you became aware of Miss Jones' statement was when you watched Lovely T's video? Is that what you said?
Objection, Your Honor, leading.
Yes, sir.
Okay.
Objection is sustained.
Okay. So, you watched that video. What did you observe?
Oh, I called Lovely T and I asked her if she knew Star Marie. And she said no because I was like, the video is pretty interesting. And so I asked her if she had any contact information. So she was the one that grabbed the live stream and reposted it on her YouTube channel. And she said, I believe her name is at the top. And so I reached out to Star Marie via Instagram direct message to ask for an interview.
Okay. And were you able to message Miss Jones?
Yes, sir. She replied directly, immediately.
And what did you ask her?
I asked her if she would be interested in doing an interview on my YouTube channel to elaborate on the allegations that she had made against Cardi B.
Okay. Did she agree?
Yes, at first. Then she was a little hesitant because of the fan situation. The fans are very interesting when it comes to these things.
Okay. I believe that now the interview. Was this of live interview like most of other, or how was the format? How was it done?
No, sir. It was pre recorded.
Okay. I'm going to show you what's been marked defendants exhibit 67. Miss Kibi, without testifying of the content of this exhibit, do you recognize this exhibit?
It hasn't showed up yet on the screen.
It is plugged in. Is it plugged in?
It's still not there.
Okay, it's up. Is it good? Uh huh. All right.
I'm
I'm
sorry.
rolling.
All right. All right. Thank you, ma'am. My apologies. Miss Kibi, again, without testifying to the content, do you recognize this document?
Yes, sir.
How do you recognize it?
It's a screenshot from my YouTube channel. It's from the Star Marie interview.
Your Honor, we moved defendant exhibit 67 into evidence.
Any objection?
No, Your Honor.
All right, 67 is admitted. Thank you.
Thank you, Your Honor. Upon defendant exhibit 67 was marked for a purpose of identification and admitted into evidence. All right, Miss Kibi, if you would please read to the jury the title of your video.
Exclusive. Cardi B's ex-friend alleges Cardi B kept a huge box filled with monostat and reveals more.
Take it. She said she's ready. Take it.
Oh.
And what date was this published?
September 19th of 2018.
I'm going to show you now what has been pre-marked as Defense Exhibit 5. All right. Ms. Kibi, do you recognize this?
Yes, sir.
How do you recognize it?
It's a video from my YouTube channel of the Star Marie interview on Star Marie interview.
And was this the interview that was uploaded to your YouTube channel?
Yes, sir.
Your Honor, defense moves Defense Exhibit 5 into evidence.
Any objection to 5?
No, Your Honor.
So defendant's 5 is admitted without objection.
Thank you, Your Honor.
Where upon evidence, defendant exhibit 5 was marked for a purpose of identification and admitted into evidence.
Let me just get an accurate time. Your Honor, we have let me see the exact time here. A 46-minute video that we intend to play in its entirely without interruption.
Yes, sir.
All right, sir. Whenever you're ready, ma'am.
Is it me?
Yes.
It's deputy.
Okay. Oh my God. Upon evidence, is that the one I'm doing? A video.
21. No, 21.
21.
Oh, okay. Oh, do you want me to dim the lights?
A little bit. All right.
Whereupon video recording is played.
In an interview we just saw, there was some discussion about monostat. What is monostat?
Monostat is a medication used to treat yeast infections in women.
Why were you talking about that?
Cardi B has, you mean, why have we, repeat the question, I'm sorry.
Why were you talking about that?
In the video?
Why was it relevant for that interview?
I mean, because Cardi B has always been like quite verbal about her yeast infections on the internet.
Have you seen anything?
Yeah, I think the first time I heard it, it was like a Rolling Stone article where she talked to, I guess, the person who was writing the article on her. And she basically yelled out, "My vagina is, I guess, itching like a screaming taco," or something like that. Don't quote me, but basically she was, telling the person who wrote the article that, she was suffering from a yeast infection.
Was this an article you saw prior to the Star Marie Jones interview?
Oh, yes. Oh, yes.
I'm showing what's been previously marked as Defendant's Exhibit 52. Have you seen this video before?
Oh, yeah.
Is this a video that you saw prior to the Star Marie Jones interview?
I can't remember if it was prior or after. I can't remember.
Do you know if this was made before or after the Star Marie Jones interview?
Mm, I'm sorry. That's hard to say,
Okay.
but it's a pretty viral video.
So you have seen it before, though.
Oh, yes. Yes, sir.
Your Honor, at this time, we move Defendant's Exhibit 52 into evidence.
All right, any objection?
Can you give me one moment, Your Honor?
A brief pause.
Violation of pretrial order, Your Honor.
All right, if y'all would approach, please.
Whereupon a bench conference was held between the court and the counsel.
Your Honor, this was one of the exhibits that was not on their original exhibit list. This wasn't even produced in discovery. And this is also not one of the videos that they cut out from their prior montage pursuant to the other order.
Okay, how can you use a video that you didn't produce in discovery and isn't on the pretrial order?
I did.
It's on the pretrial order?
I have it. I have no idea.
Why don't you take a look?
I mean, I found my new exhibit list. I'm sorry. If I may, what she's complaining of, they did the exact same thing, and we allowed it all last week. So I'm not really sure what the objection is.
All right, so here's the question.
I have no idea.
It was not.
Hold on a second.
Sorry, Your Honor.
Are you going to let me talk?
Yes, sir. I apologize.
Okay. All right. So I don't know what you allowed last week. I don't make rulings on objections based on, for example, hearsay. The fact that you didn't object to someone else's hearsay, I don't let you get into hearsay. If I did, then probably all the questions you asked that were hearsay, I could have allowed in. I have to respond to objections. The plaintiff has made an objection that this document, this video, is not on the pretrial order. Whether it's on the exhibit list or not doesn't control it. You need to go check and see if this and any other exhibit you intend to use is on your pretrial order.
Okay.
And if it's not, you've got to give me the reason why you should be allowed to use it, despite the fact that it wasn't.
Okay. And so if Your Honor is aware that we did refile our exhibit list per our individual agreement, the plaintiff.
No, we did not have an agreement that you could just add on new exhibits. The new exhibits we had, Your Honor, just so you know, half occurred after the pretrial order was filed, and that's not even at issue right now. We had an agreement mutually that we could add until October the 20th. This came last week. This was not agreed to, and I don't even know where it came, just to be honest.
Hold on a second. I don't know about your agreement, but aside from the agreement, when was this video produced to the plaintiff?
This was part of a collaboration, or I'm sorry, I'm almost certain this was part of a montage that we had a pretrial hearing about, Your Honor.
Okay, almost certain doesn't do it for me.
Well, I mean, I'm not judge. The point to me be
Okay.
because
Okay. All right. Okay. So she can't point on an exhibit list and say this document is not there. You need to point to me where this exhibit is on your pretrial order. So why don't you go take a look at your pretrial order and then let me know where it is?
Okay.
Thank you, Your Honor.
Whereupon the following proceeding continued in open court.
Your Honor, it's number 52 on Your Honor's exhibit list. I'm not sure exactly what.
I asked you about the pre-trial order. So is this document on the pretrial order, the order that was entered by the court?
It's on the exhibit list that we were filed.
Oh,
So your answer is no. It's not on the pretrial order?
I just I just don't understand what you're asking.
Oh,
oh my
okay. The
God.
pretrial order has an exhibit and attachment to it that has all the evidence that either party might use at trial. Was it listed on the pretrial
Oh my God.
order?
It was filed. It was
Oh,
listed on the most recent exhibit list, and both parties filed last week.
oh my
Okay, so
God.
your answer is it's not on the pretrial order.
I don't know, but I know.
Why don't you look and see if you can find it on the pretrial order? That's what governs the case, absent some further order of the. I'll tell you what, I'm going to ask y'all to step out and I'll call for you as soon as I can. We'll probably take a break before I call you back just so we don't have to break again. So if y'all need to go to the restroom or go downstairs, then go ahead and do it now.
Arise! Upon whereupon the jury exits the courtroom.
Y'all can now have a seat, please. All right. All right. So the pretrial order is docket 159. And then let's see. The plaintiff's exhibit list is attachment G1. I presume then the defendant's exhibit list to the pretrial order would be G2.
Yes, Your Honor. It is G2.
All right. So I am now at attachment G2, defendant's exhibit list. This video would be found under which number, if any, of the list of exhibits on the defendant's exhibit list?
Your Honor, it would be 718, but I believe this was part of the video that Your Honor that they objected to at the pretrial conference. It was a montage, and the court instructed us to break it up. I believe that's what it is. I'm trying to confirm that.
718?
Yes, sir. The montage included 200 clips.
718?
Kiwi 718, sir. My apologize. That's the date number.
So the exhibit list that I have to the actual pretrial order stops at plaintiff, Kibi, or the defendant's exhibit 362.
Wow.
Yes, sir. The pretrial conference, sir, was filed prior to the pretrial conference. At the pretrial conference is when they objected to the montage of 200 clips. Your Honor said if you intend to introduce any of those, you need to cut the clips up, which is what we did and reserved it.
But the montage is found under what document number?
That's what I'm trying to figure out right now. I don't know. I don't know. It's in there, but
It can't be a number greater than 362.
I just have to, it's going to take me a second to find it, but I know it exists.
Let's find it.
And I will, sir.
Whereupon there was a pause in the proceedings.
All right, so let me ask this. In light of this clause that was included on the back end of the selection of the pretrial order that talks about exhibits, is there a subsequent list that was produced in exchange between councils of October 2021 or earlier that would have shown this document either as it exists today or as part of the montage?
Your Honor, if I may refresh your recollection about the pretrial conference, because as you recall, I was making the argument.
Okay.
At the time we filed the pretrial order, both sides agreed that we would be able to add more exhibits to the exhibit list from both sides. There was an agreement. It's written in the actual pretrial order that we submitted to the court.
Right. That's what I'm looking at. But it says up until Wednesday, October 20th.
But when we had the pretrial conference, if Your Honor remembers, on the 9th, I believe it was, of November, we went through everything. Your Honor, at the beginning, specifically stated that neither party's exhibit list was in conformity with what the court wanted it to be. And you directed us to edit them and make sure they were, not all long as they were at the time, and to basically use the forms that the court wanted us to use. And so,
Yeah, but that's okay. Let me just stop you right there. The form has to do with a form that I use and that I've been using to admit documents. Once you talk about documents, I make a mark. Once you tender a document, I make a mark on this form. And if there's an objection made, I normally make a mark. And then if I admitted the document or thing, I would make a mark to keep a record so that I can double check what's been admitted and what hasn't. There's nothing about that, though, that extends any time period. I mean, under the normal federal rules, the exhibit list is firm as of the date of pretrial order. In this case, the parties reserve the right to amend the pretrial order. I guess I've agreed to that because I didn't object to its inclusion in the pretrial order, but that's only through October 20th.
Your Honor,
So, is this document listed on any exhibit list exchanged in between the parties as of October 20th?
I believe if it's in the compilate compilation, I don't know,
Compilation.
compilation. Okay, thank you. Then it would be Bates stamped Kibi 258. If it's in that compilation of those Instagram videos.
Okay, well, this is a video. So, date stamps, how are you date stamping a video? Just with reference to it.
Bates.
That's how we
Okay.
identify for our purposes and for purposes of when we serve it in discovery.
Well, let's look at that and see if the document that you've just identified, the exhibit that was referenced, includes this or not. If it doesn't include this, then we've got a problem.
If I also may, the other video that were right around the same bait stamps when we cut them up. Now it has bait stamp, Kiwi 718. And wherever it is, and other videos right around those same numbers were already omitted into evidence.
Okay, so what difference does that make?
So that means that we did serve it to you. Serve it to them at the same time as those other videos.
Because you tendered it in court and it was not objected to, that means it was served?
Because we labeled exhibits in
Wow.
chronological order, Your Honor.
Okay. Let me just be clear. This is your case.
Okay, yeah.
You contend that this document, this video, is a part of an exhibit that was previously identified consistent with the pretrial order and the clause that the pretrial order has in it. So you should be able to point to where it was referenced. If you can't point to where it was referenced, I can't admit it absent an agreement of counsel because they have objected. So just point to where it was. This is your case. It's not mine. I can't find it.
It's referenced in the defense exhibit last, which we've exchanged with counsel.
Okay, show that to me. Show me. Not the defense exhibit list. You want to compare apples and oranges. Well, what y'all exchange before trial is irrelevant for the pretrial order. The pretrial order is the governing document. That's pretty standard, right?
So then all the exhibits that they've introduced on their case in chief that they've served to us literally 1 week ago before the first time ever, we should have objected to those as well.
Oh my
Maybe
God.
you should have. They are objecting. And so all I can do is go to the documents. And so I'm asking you, per the documents, to show me where this video was listed. If it's listed, you can admit it subject to, other foundational and relevance considerations. But if it's not listed, then you've got to give me a good reason. The only reason I'm hearing is because we let them, quote, because we let them introduce other things. Is this a video that you would have always had access to, right?
It's a video that's on the internet. So I would imagine so, yes. It's relevant because it's the plaintiff's own words discussing the exact topic that Mr. Sivic was just questioning our client about, which, and he asked her, has she seen this video? And she says yes. So it also goes to show that it also goes to show what information she had in her head when she was making those statements. So that's the purpose of this document.
Okay. Relevance is certainly a consideration. I'll take you at your word that it's relevant. But if it's not on the list, then why should you be able to introduce it?
Because, in all honesty, we were under the impression that if we serve the discovery just like the plaintiff served the discovery and we served it in time, no objections were made. And then they served us their exhibit lists. We served, you know.
I'm sorry. No objections to discovery. What do you mean, no objection to discovery? Because they didn't file a motion in limine to keep it out?
Correct.
That's not the way the law works.
Oh my God.
I mean, I really didn't foresee this happening because we never had any conversation about the fact that, oh, you're serving this late, or any of those types of conversations, because they literally were serving us discovery up until 5 days ago, maybe 6 days ago.
They served you something 5 or 6 days ago that you didn't have?
Not before that day.
Now, certainly that may be true as it relates to invoices of recent.
It wasn't.
Recent. What is it?
They were the photographs of the plaintiffs with all of her tattoos back from 2016, 2015, and all those photographs that was introduced into evidence.
The video is how long?
It's maybe, I don't know, 15 seconds. Let's say maybe 30 seconds.
And it goes to show exactly what?
It goes to show that the information Miss Kibi was relied upon when she, making her own statements in her own video.
Play the video. Let me see it.
Yes, Your Honor.
So, I know what you're talking about.
It goes to the tweet at issue, Your Honor.
I don't read. That's been 30 minutes ago now.
That's fair.
Upon a video recording played.
That goes to the testimony that Ms. Kibi gave about Star Marie Jones' testimony about Monistat or what?
It explains this tweet, which is on one of the claims.
I'm sorry, it explains exactly what about the tweet?
Yes, sir. So this was one of the tweets that is part of the claims when Ms. Kibi refers to irritated PUSSY. She's not saying the plaintiff has herpes or anything down there. She's talking about the monostat and the yeast infection, which is what Star Marie Jones described, which is what the plaintiff talks about in that video. So it explains
I'm sorry, it's not. Say that again. It's not what?
So when Miss Kibi says we left you and you're a confirmed irritated pussy in 2018, she's not talking about herpes. She's talking about yeast infections, which is the whole monostat video. They're trying to say that Miss Kibi is referring to herpes, and we are trying to explain why that's not this case.
Okay. So my question is, do you think the jury is an idiot? I mean, it uses the word hashtag herpes. And that's not going to be her answer. And that's going to be her answer. Is I was referring to a video where she was sitting in a cab, not wearing underwear, and explaining why she was. To give her body a break, that's like That's ridiculous. I mean, that basically assumes that every juror that we selected just has no common sense. Herpes B is in the hashtag. I mean, if the plaintiff's lawyer, I'd I'd probably let it come in because I think it just totally blows away any credibility out of the water as to that contention, which then the jury is able to take it and say, well, if we can't trust her about this one tweet means that we can't trust her about anything. I mean, that may be. There's an old instruction given under Georgia law, and there may be a similar one under federal law that basically says that when a witness testifies about something and is found to have lied about it, you're entitled to disregard, you're entitled to disregard all of the balance of their testimony unless it's otherwise corroborated by evidence. And I just don't think any reasonable person would look at this tweet and say, oh yeah, she was talking about herpes at all. She wasn't talking about herpes at all. Herpes B hashtag. So I don't know. I don't know what to do about the documents exchanged between the two of you at the late hour. Certainly a list of documents, there can be grounds for expanding the list of those documents by later discovered and or innocuous documents. The photo of the plaintiffs, the photos of the plaintiff's various tattoos or body art saves the jury from potentially, having to examine those tattoos in court, and saves the plaintiff embarrassment of having to unclothe in court to show the jury what she could legally do.
Wow.
Because she wouldn't have to put a demonstration of tattoos on the exhibit list, right? You would just have to take your clothes off and show someone. So I don't really think that that's that much of an accommodation from the standpoint of surprise. I mean, I'm going to guess the defendants knew that the plaintiff had tattoos, and so we're not surprised by that. The issue of a photograph of the plaintiff's when she was, a preteen, likewise, I'm not sure provides anything surprising if it's her. The defendant did not object to that document. All I can do is really react to what happens in this court. As I mentioned on our sidebar, the plaintiff asked a ton of leading questions, and I suppose strategically the defendants did not object. The defendant has asked some leading questions or had been asked some leading questions, not all of which have been objected to, but some of which have been objected to. Now, if I was following they got to do it so we get to do it rule, then I would have denied the plaintiff's motion or objections for leading questions because the plaintiff certainly asked leading questions to its own witnesses. But as I told y'all pre-trial, I rule on what I'm asked to rule on. And so now, just like I wasn't asked to rule on plaintiff's leading questions, so I didn't rule on them, and did rule on defendant's leading questions when asked, but not the ones that I wasn't asked. And I'm now asked to rule on an exhibit, a video, which apparently is not on the exhibit list through the date of which the pretrial order. So all I can do is go to the document that I've got. I'm not party to what y'all were thinking and what y'all felt was fair or right. I'm governed by the document, and I'm not being given a compelling reason why you should be allowed to introduce this based on what the documents say. Certainly, this is not innocuous like a photograph of the plaintiff when she was a preteen, or photographs of the plaintiff's body art that she should have otherwise demonstrated in court anyway. So if you can't find a document through the exhibit list of October 20th that's referencing this particular video or exhibit, then the court's ruling is this video does not come into evidence, and it applies to anything else the defendant might seek to introduce that the plaintiff objects to. So one more time for the people in the back. An exhibit referenced through October 20th, which is what the pretrial order says, then let's take a look at it. Otherwise, we'll take a break and move on.
We're ready to move on, Judge.
Okay. Let's take a 10-minute recess. We'll see y'all at 3:10.
Lord have mercy.
All rise.
Wow.
Wow.
Brief
I'm
recess.
loving it.
Got
Wow.
checked in the door.
Wow.
Mm, mm, mm,
Wow.
mm, mm. All right. On that, where we gonna stop? Or did you want to continue?
It's up to you.
Oh,
Your channel, your rules.
I want to continue. I want to finish it off.
Okay.
All right. Here we go. I'm coming back. All rise. This is the honorable court is again in session.
Right, come on back up. All right. So before we bring the jury in, let me just say, as far as this last document is concerned, the ruling preventing the document from being used at this time does not prevent the defendant from answering questions about why she said what she said or what she was relying on when she said what she said. That doesn't mean that the document is inadmissible, of course. There's there always could be things that could occur in the balance of the case that would make a document that was not otherwise admissible thereby admissible, you know? For example, the plaintiff could open the door for some reason. I don't expect that to happen, but maybe it does. And if it does, then you can seek to introduce it at that time, all right? Anything else?
Yes, just briefly, Your Honor. And they didn't object before, but the screenshots of the titles of the videos, those were also served at the same time as this video that just got objected to. Now, previously, they didn't object to our introduction of that. They do have all those lists on their own exhibit list. So I just want to make sure we're not going to have any issue, or should we just call out the plaintiff's exhibit number instead of our own to introduce those?
Okay. So we're talking about something you have not yet tendered and has not yet been tendered.
No, but it's about to be.
All right, Miss Motts, what about that?
Um, I don't know exactly which ones they're talking about, but Your Honor, I'm trying, as I said, we're not objecting to everything to the extent that it was on our list in some way, shape, or form. I'm not making every objection under the book. I'm trying to be mindful of that. But like I said, we were unable to find that one in the compilations, and that's why the objection was tendered to the video. I am obviously going to see. I'm not going to say that I don't have any other objections based off of anything they added to their pretrial order, because I do, but I'm not going to be making it to necessarily everything to the extent it was already on our list. And I think the one they introduced earlier, it was related to a video we've introduced. So obviously I didn't object to that. I just made the court aware of the issue.
Okay, when the defendant refers to the plaintiff's list, what list are we talking about? Are we talking about the list that they've submitted on the first day of trial or the list that was included with the pretrial order?
The list is submitted on the first day of trial, because the list submitted on the with the pretrial order didn't have any descriptions of anything like that.
Your Honor, I'm sorry. Do you mind if I address this? I think this is a little bit misleading. First of all, documents were exchanged in discovery and everything was Bates stamped. So I understand at the last pretrial conference that Your Honor wanted descriptions and wanted everything formatted in a particular way. And we've done that. And we absolutely want it to be in a form that's workable for the court. The list that we serve with our pretrial conference order, it is not as if these were served in a manner in which the defendants didn't know what they were looking at, because both sides did their initial exchange based upon the Bates numbers that everyone used in discovery, which is usually a unique identifier. And it is not as if we added things, willy nilly after the fact. There's been a lot of accusations thrown about why we did what we did. And I would have been happy to explain any of those to the court and still would be.
Well, I don't know that I need any explanation right now. You know, for both sides, I'm operating with the list that existed as of October 20th. And if there are other things that either party seeks to tender that's not on the list and there's an objection, then unless there's a good reason, like we've only discovered this document after the date of the pretrial order and thus could not have listed it on the pretrial order, that would be one example, then the document generally won't come in. That's why pretrial orders exist, to make sure that everything has been exchanged and is known by each side. Obviously, if something is subsequently discovered, then that was impossible, perhaps. So, I mean, that's the only way I know how to handle any objections to documents that are not listed on the pretrial order.
Just for the record, we have exchanged all of the documents listed on our, even the exhibit list that you have in the front of your honor, and just like Dave had them in advance of trial.
It doesn't matter. You don't get to just rewrite the rules of civil
Mm,
procedure as
come on.
prescribed in federal court just because you've done something else out of the court.
Wow.
And I understand that in criminal law, you don't have a pretrial order that
Yeah.
governs civil cases. But in civil cases, under federal rules, you do. And that is the governing document. It is not the end all be all. There can be exceptions made, but there has to be a good reason. And absent a good reason, then I cannot make an exception because that would be an abuse of discretion without good reason. And a good reason is, in my estimation, is not because we let them do it. I just, that just doesn't satisfy what I think a good reason has to be. It has to be something based on the circumstances and why it was not listed to start with. Okay?
Okay.
Oh, all right. Let's bring the jury back, please.
Ooh.
All rise. Upon the jury entering the courtroom, please be seated and come to order.
All right. The defense can ask her next question.
Thank you, Your Honor. Tasha.
No, that's you.
Ms. Keeley?
It's
No,
still you.
you're addressing Miss Keith.
Oh, I'm sorry. Thank you, Your Honor. Ms. Keeley, I'm showing you what's been previously marked as Defendant Exhibit 76. Do you recognize that?
Yes, sir.
How do you recognize that?
It's a screenshot from my new YouTube channel.
Your Honor, we moved Defense Exhibit 76 into evidence.
Any objection?
One moment, Your Honor. No objection, Your Honor.
All right. 76 is admitted without objection.
Thank you, Your Honor.
All right. Upon defendant, Exhibit 76 is marked for purpose of identification and admitted into evidence.
All right. Ms. Keeley, if you would read to the jury the title of your video.
Actual proof Cardi B knew her ex-roommate, Drake Funky Dineva versus
Thank you.
Tamar, Beyonce, and Black Magic.
And if you would, ma'am, please let the jury know about what date is what date is that? I don't know if you can make that out.
Yeah, it's hard, but I know what date this video is. I believe it's September 21st of 2018.
And do you recall many days after you published the Star Marie Jones interview to your channel, did you publish this?
2, I believe.
Okay. All right, Miss Keeley. I'm going to now show you what's being previously marked as Defendant's Exhibit 11. Do you recognize this?
Yes, sir.
What is this without testifying to the contents?
This is
Objection, Your Honor. Before the witness discuss this is a violation of the pretrial order.
All right. So generically describe what this is. I'm guessing this is another video of one of your performances. Is that right?
yes, sir.
All right. So if y'all would approach, please.
Sit back.
Okay, defense moves defendant's Exhibit 11 into evidence.
Okay. So there's an objection. Let's talk about that.
How he just
Yeah.
where whereupon whereupon a bench conference is held between court and counsel.
Okay, what about that?
Let me double check to make sure this one was redacted.
okay.
Your Honor, there's no violation in there.
This discusses the federal indictment of the bartender's case at 8 minute and 37.25. It discusses the alleged drugging and robbing of men at 38. So I realize there's portions of this that are not objectionable, and I don't have an issue with that, but
I'm not sure that that's correct.
What do you mean you're not sure if that's correct?
I don't know about that one.
All right, so here's what happens. If you play it and it violates the pretrial order,
Sure.
then the plaintiff can move for a mistrial,
Woo! I understand.
which they would probably receive if they wanted it. And then your client would be sanctioned, or you would be sanctioned for the entire cost of this trial, which might include plaintiff's legal fees. So you need to be sure.
I got you.
So you're
Uh-oh.
sure?
Do you want to give me the timestamps that you have?
wow. Yeah, I'll help you out. No, that's not what it says. I have 3 of them. But what timestamps are you playing? Not every video has this issue. I just don't want it to come out of your client's mouth before, because
I have to verify that. I don't recall that in the videos. That's all. I mean, there's a lot of,
and I know a lot of these videos are very
and they run very long. So, I mean, I can't.
I don't know what portions you're planning on playing. Well, then why don't you tell me which portions you're planning on playing?
Let me see the timestamps. I'll look over it and if I'll let you if they're referred to this video.
I know it includes these 4: 37, 38, 44, and 113. But I don't know if there's others. And that's why I'm asking what you're planning on playing.
I plan on playing the video in its entirety. So I don't know that is correct. So we can watch the video, but what?
Well, I mean, sorry, Your Honor, I don't want to talk if you're thinking.
Well, I mean,
We reviewed our videos before we played them.
so the plaintiff is saying that this video has objectionable material and you're saying it doesn't. So what happens if we play it and it does?
What Your Honor just said.
Are you asking for a mistrial?
No, sir. Can I have 5 minutes to?
Are you saying for the court that you're certain that this video doesn't have those things in it?
I'm saying I'm not certain.
Lord have mercy.
Well,
Do your job.
well, then aren't you supposed to be? I mean, isn't that, wait a minute, isn't that what motions in limine are all about?
Wow.
Is you get the rulings and you go and you form your documents and your videos based on that?
So we are all under the impression that does not exist in there. I'm not saying she's a liar.
Oh,
I'm saying now I don't know, but my whole team is under the impression that that's not in there. So I don't know what I'm is supposed to do. What?
Okay.
wow.
Okay. All right. Let's play it and let's see what happens. I mean, I'm not going to sit here and go through every video. If it's in there, there's going to be serious consequences.
Come on. Of course. Could we have 5 minutes to verify it?
I'm just going to leave. I'm just going to leave it. Look, we'll just have to trust that he's doing his job. Otherwise, then there'll be serious ramifications.
I understand that, sir.
Look, I can't have an objection and then pre-listen to every video before it's played. I have to trust that the lawyers have done their job. If they've not done their job, then I will react accordingly.
Of course.
Yeah, that's all I can do.
I understand. Look, Judge, she just put this in our lap. What? Can I have what's that? 3 minutes to verify it?
It's not her responsibility to make sure that the video you intend to play doesn't have what the court has already ruled out. That's your job.
Do you have your timestamps then to verify? Let me.
All right, listen. I'm not going to make a representation that these are the entirety of them, but I'm sorry. Go ahead, Your Honor.
I'm listening.
I know there's something at 3725 about the federal indictment.
But does it say federal indictment? What does it say specifically?
I don't have the quote,
Oh
but
my
again,
God.
you've pre-reviewed all our videos to ensure
Mhm.
that none of them violated the pretrial order. And
So,
excuse me, I'm talking.
uh-oh.
And only played the portions that did not. We were very careful at the same things.
Let's talk about this. This does not talk about a federal indictment. This doesn't reference a case that she has in the active civil or criminal case for.
It talks about the bartender case. It talks about the bartender case.
There's two bartender cases. There's one that she's being sued for, and there's one that was involving Nicki Minaj. That's all she's talking about.
There's also at 38, there's a drugging and robbing men. At 4450, there's an entry of a federal indictment. And then now at 1330, something about a federal case. And frankly, even if it's to the extent it is talking about your client is referencing a federal indictment to be finished up and exists, and she means a state court indictment that does exist, either way, it will fall under, shouldn't you know?
Should you know because you're the one saying it,
What?
Sarah?
Huh?
It doesn't say that in my point.
All right. All right. All right. So in total, how many
Wow.
hours of videos do you intend to play?
So I have 2 hours call. I have a 2 hour call. This one is supposed to be 46 minutes. I might have one more video, Your Honor. So we're looking at 3 to 4 hours.
All right. Y'all have a seat.
Yes, sir.
Thank you, Your Honor.
Whereupon the following proceeding continue in open court.
All right. Ladies and gentlemen, I'm going to let you go for the day.
Because
I'm going to ask you to return in the morning or tomorrow.
this is
Actually,
jacked up.
actually, not in the morning. I'm going to ask you to return at noon. I've got to have some extensive discussions with counsel
Wow.
to make sure that the evidence you receive is proper.
Wow.
As you know, I don't want to try this more than once. This is a long trial, and I want to make sure that we get to everything right to start with. Sorry that this is going to be invariably delay. This is invariably going to delay the conclusion of this case. In the greater scheme of this case, it's what is in the best interest of making sure that we only try the case one time. Now, I would like to ask if you would leave your notes in the jury assembly room, and we'll see you tomorrow. Let's do this. Let's have you return at 12 o'clock tomorrow. 12 o'clock tomorrow. That gives us plenty of time, and still that gets in at least a full 3 sessions in the afternoon. Okay? We'll see you tomorrow. Thank you.
All rise. Upon the jury exit the courtroom.
All right. Y'all can have a seat
All
for
right.
a minute. I'm not going to stay in court and listen to these videos, but the lawyers are going to review the videos before they're admitted. So I want the plaintiff to receive I'm not sure what you call the meter, the meter running time of each video that the defendant intends to introduce at trial, and then have an opportunity between today and in the morning to review it. You know, frankly, if I had thought a little bit more clearly in the moment, I would have told the jury to come back first thing in the morning because I was thinking I was going to be sitting in the courtroom reviewing these documents with you, videos with you. But I'm not going to do that. I'm going to let you look at them. And then in the morning at 10 o'clock, I want you to appear and, well, say 10:30 to appear so that I've have enough time to hear any objections that the plaintiff might have to whatever the defendant wishes to play and rule on that and still give you an opportunity to have a little time for lunch before the jury appears. I told the jury 12. Yeah? So let's say 10:30. Frankly, it is remarkable to me that we have reached a point where mid-trial during
Mm,
the defendant's case that I've got to have the defendant tell us exactly what it wants to
mm,
introduce by way of video or audio testimony for the rest of your case. But I have no choice but to do that because the defendant has not given me any assurances that in the videos it wants to play that there are materials that have been excluded
mm.
by the pretrial order. Instead, counsel is asking plaintiff to tell him what's in there that's objectionable. Come on, that's not the way this works.
Come on.
Wow.
We had a pretrial hearing. We had motions in limine that were argued. I made rulings. It's counsel's job to go and review what they intend to introduce and to redact or remove anything that the court has prohibited. Mr. Sabak, if you had been able to tell me with any degree of certainty that the material that the court had excluded was not in these videos, then I would have said, let's just go ahead. In fact, I initially, that's what was going to be my direction, is that we just go forward. But honestly, the back and forth between you and Ms. Motts about what might be in there, what's not in there, you're relying on the plaintiff to tell you where the objectionable material is for a video that you should know everything about, doesn't lead me to believe that you really know if it's in there or not. And that maybe you don't really care. Because if it comes in, then the plaintiff is left trying to make a decision. Do they want a mistrial or do they want the case to go forward with instruction to the jury to disregard the bad stuff that they wanted to keep out? I say bad in quotes because it was such that they didn't think it was admissible. So it's basically, allowing the jury to hear what they're not supposed to hear and telling them they have to disregard it. And while juries have to do what they're told to do, that doesn't mean that they do what they're told to do, particularly on
Right.
something that's in their brain that
Right.
I can't remove.
Yep.
Right.
So it's what, 3:35 today, 3:33 today. Before y'all leave today, I want all of the material that you intend to play with as much specificity as required given to the plaintiff so that the plaintiff can view it tonight. I would also like, if there are any objections that the plaintiff has, to go ahead and note, because you're going to have to look at it tonight. Go ahead and get that information to the defendant, and y'all appear at 10:30 tomorrow, and be prepared to talk about it.
Wow.
If after reviewing everything, the plaintiff decides that there was no objections, that you're going to have to have it, then y'all otherwise appear at 11:30. Both with emails back and forth communicating that there are no objections and that it's going to move forward. I say appear at 11:30 so that if there is any other issues that come up, like we do every day when we arrive 30 minutes early, then we can deal with that. Any questions from the defendant?
Thank you, Judge.
Mm-hmm. Any from the plaintiff?
I just want to make sure. So we're going to have the list of the numbers and time codes by 5 p.m. today. That's the
You'll have them before they leave court today.
Wow.
They need to tell you everything that that they hope to admit into evidence. That involves audio or video. If it's photographs, then you can react to those because you'll see that. I presume y'all see them just like the witnesses see them, like I see them before the jury sees them. So you know what it is. But if there's video, you need time to actually watch it.
absolutely, Your Honor. Photographs, I can agree, we can see them.
And Your Honor, when will we get the objections in order to make any redactions if they're actually legitimate?
I don't know. I mean, it depends on how long it takes them to review it all.
Just so the court knows, we did redact the videos. Let the Star Marie Jones interview, like the Star like the Star Marie Jones interview. There was stuff redacted from there that was inadmissible.
After the
So,
fact. Oh, sorry.
so I personally watched this video. I do not believe that there's anything in the video that we are planning to play that violates the pretrial order, which is the reason why Mr. Sebek is confused, because we did do the redactions of the videos that did have, and no language or whatever that violated the pretrial order.
Well, so the transcript of our bench conference will be in the record of the court at some point. But the best way I can put it is Mr. Sabak was less than 100% sure that there was no objectionable material included. So given if he had stood there and said, Judge, absolutely, we did it just like you did. We did it. There's nothing in there that violates a pretrial order. I would know there's not. So objection is meritless. Then I would have said, okay, so let's go forward. We're ready to see the video. But that's not what he said. He wanted the plaintiff to tell him where the bad stuff was so he could go and take a look.
Wow.
I just don't want it to come in when it's not supposed to. I don't think it's fair to the plaintiff to have to make a judgment call at the spur of a moment about whether they want a mistrial if something comes in that's not supposed to come in. So this is what we're going to do. So we'll see y'all at 10:30. If the plaintiff has any objections that y'all can't work out tonight, and if y'all work everything out tonight and you don't need me at 10:30, then I'll see you at 11:30 tomorrow. I'll be here notwithstanding, because as fate has it, I've got to take 2 dogs to the vet at 7 a.m. in the morning. So I'm coming in at 7 a.m. in the morning, I suppose, but I'll see y'all at 10:30 or 11:30.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All rise. This court stands in recess.
Wow.
Upon the proceeding, they're adjourned at 3:35.
Good Lord.
Lord have mercy, y'all.
you
Oh
believe
This
my
is a man.
God.
They done gave me a headache.
Gee, bullies.
Guys, what do y'all think? Dr. Sherry, what do you think? Dr. Sherry?
She's muted.
Dr. Sherry.
Is she still here? Oh, did she?
I'm right here. I'm here.
What do you think?
Hold on. Dr. Sherry needs to see a doctor, because that right there took me out.
My goodness.
I was
Yeah,
like,
she probably did.
I was like, let me call and make me an appointment with somebody.
Everything y'all said, Sylvia, Choke, and Dennis said was right. They was all confused, messed up, didn't have the information right.
Yeah.
Wow.
Wow.
Okay, Sylvia.
Attorney.
So when the video came back, were they allowed to play it, or was it all messed up? What happened? What happened?
Dun dun dun. That's to come. That's a cliffhanger.
Yes, Isabel. I sat through the conversation. I came back and told y'all what happened.
Yeah,
I don't remember now. Tell us now. Tell us now.
The cliffhanger.
The next morning, I was there early in the morning. And they were trying to, like, they're running like a chicken with the head cut off. And I remember they did redact a lot of this stuff. They cut a lot out of the video. Yeah.
So that meant that they had not done it.
Which meant they were gonna cause a mistrial.
Wow.
They were trying to sneak things in.
That's what it seemed like.
They were trying to sneak things in. Yeah.
Did they just
Laura Holland, I think it was all of that.
Exactly.
I think that they didn't have that
Confused.
video really in evidence like that, did they?
I think they were just really unprepared. I don't think they were trying to cause a mistrial. They were just silly.
I think it was a combination of
Yeah,
everything.
it definitely wasn't a strategy because they don't appear to be smart enough to pull a strategy like that together.
Mel, let me tell you, your judge reading is
Not
on
smart at
fire.
all.
Uh-huh.
Oh, yes.
I got it. I'm look.
Yes, it is,
That
honey.
judge wasn't playing.
Yes.
I
Hey,
love it. I love it.
I was like, I'm scared of you. Ooh, the judge about to smack hand down.
They tried it with the judge.
They
Boy, that's
did. They
ridiculous.
did. They did.
This is the judge I wish R. Kelly had.
Because
Exactly.
he was like, look at here, look at here.
I was just thinking about I'm sorry, we keep having to bring that up, but I was just thinking about when that judge was telling them that they can't change stuff, and they did. They changed stuff in the middle of trial for R. Kelly.
Yeah.
Yeah. And he also gave the rule that I only fight things that are objected to. The judge in R. Kelly's case objected for prosecution. She was the one yelling, objection. No, you're not a lawyer, ma'am. You're not a lawyer. You're the judge.
Right.
Wow.
In that position, that shouldn't have been. Yeah.
And
They're
also
supposed to address objections.
when Judge Ray said that the jury cannot take out of their mind what's already been put in, when they had said that this was not a RICO racketeering, but the jury already have it in their mind.
Right. Yeah, this judge was really trying to stay within the confines of the law. I really appreciate him for that.
Right.
I like him.
Right. And he was getting on both sides. So, it wasn't like he was biased.
Right, 'cause
he was really
when
getting
he
on
came
both sides.
for I'm sorry. I'm so sorry. When he came for the defense, he threw in that the prosecution was leading too.
Yeah.
But you didn't object.
Exactly.
So
I couldn't object for you.
But and when they got to that part, I was wondering, I was like, I'm sure Cardi and them's attorney was like, oh, okay, so they ain't gonna object to this. Okay, but sure, we're gonna keep it moving with it.
Keep it moving.
Mm-hmm.
And after they probably realized they don't know what the heck they doing. Now we'd like to submit 50,000 more exhibits.
Look what Sheree said. I thought Tasha K said she had money. Where did she get those lawyers off the back of the cereal box?
Ooh-wee.
Tasha K capping in the internet about appealing. After hearing this, I don't see how she could appeal.
And she has to,
effective
Thank you, Ashley.
but she can't say that. That's only in reference to criminal cases. That does not fly in the civil case.
No
ineffective counseling. No.
She has
in the
no
federal
ground.
court. That only happens in criminal cases where you can claim ineffective counseling.
But too, I like how Cardi's lawyers, they at least try to throw him a little piece of a lifeline.
Yeah.
You know what I'm saying?
A little bit too.
My goodness.
I can't believe that the arguments were, we didn't tell on them. Why are they snitching on us?
Exactly.
Yes. We didn't object to them giving us stuff late.
They're not playing fair, Your Honor.
Isabel said, I can't believe people aren't listening to these readings. It's awesome listening to you all. What a brilliant idea. So listen, Isabel, the thing is they want to keep believing the lies. You see that? They want to keep believing the lies. That's the problem.
Yeah.
We need a mention from one good person. At Cardi B, we need a mention.
Cardi B,
infamous
you're in the
Sylvia.
chat.
Can we get a share so we can get the story out?
She ain't gonna do that because she don't want the truth to come out because she's talking about it never happened.
I didn't say Tasha K. I said Cardi B.
Oh, sorry.
No, we want Cardi. Cardi, if you're in here tonight, please.
Can we get one at?
We need an at, Cardi, so that people can come in here and see what really happened in court. That's what we want, your truth to be seen. And only you come in here and say something, and then we could blast it everywhere.
We need one of those wake up in the morning with 10 million views on that.
Yeah, because we had a glass of wine.
Amen.
Because we had a glass of wine and a negligee on.
Right. Really?
Oh, is that what we needed? Somebody, look, one of y'all turn on your camera.
that worked for Tasha K, according to the transcripts.
That's what I'm saying. One of y'all turn on the camera.
A negligee on, but I was angled down. You see what I'm
Uh-huh.
saying? I was angled down, and then I went to sleep because I had wine.
And my husband was like, "What did you do? Take it down. Take it
Isabel, she was
downtown."
here. She was here yesterday, and she was here the day before. The attorney Sherry was in here too. Her attorney
Hmm.
Lisa. I mean, not Sherry.
Yeah.
Why
Lisa
I say
Moore.
Sherry? Lisa
Lisa
Yeah.
Moore.
was here yesterday.
Yeah.
They should have. I mean, well, it kind of gave me a different view of her husband because he said, take that mess down. And she took that mess down. And then she had to sneak to have her YouTube.
Right, right. And then remember at one point he said, "You don't know that." Remember in
Yeah.
for
Yeah.
that. So, you know.
I think he might have had a conscience, but he was following suit because that was the paper. That was the
And
money.
Yeah.
That was the, and so it
right.
was like,
Which
okay,
retired
she
him
knows
from
what she's
working as
doing.
the manager at the restaurant.
And that was
Right.
also in the beginning. That was pre the Unwind with Tasha K.
That
So,
was when he was still paying all the bills
right.
in two
Right,
houses and
right,
working.
Hmm.
right. Man, this is something else. I mean, it's like, how do you say, "Okay, can you help me with my case?" Um,
Right.
opposing counsel,
Right.
tell me where it is, please.
But what
You know,
what I don't understand is why Olga came back and tried to, well, see, you know what, Judge? See, we knew. And then the judge had to go in on a whole nother rant. Yeah, if
yes.
Sabak would have known what he was talking about at the time, then
You know what? She had to stand in for Shabbat. I mean, stand up for Shabbat because Shabbat was looking a whole mess. And
mm,
even though she looked a whole mess, she was less of a mess than he was.
Mm-mm.
but they was both a
Yeah,
mess.
Isabel, we are
Yes.
the only one reading. Mel reads on hers, but Mel, myself, and Dennis are the only one with the
Oh,
transcript.
thanks, Isabel. So sweet. Thank you, girl.
Mm-mm-mm. Wow.
Yeah, this
We're
was
the only
just
one with the transcript. We're the only one who purchased the transcript.
right.
This,
So
it's just,
now I will
and what
tell
I don't.
you.
Oh, sorry. Go on.
Oh no, I was just gonna say, and Sylvia, so I did like a recap of last night's reading about when Dr. Blake testified about, the mental health wound, the internal bleeding part of it.
Mm.
Oh,
Hmm.
that had kept me up all night after.
Yes.
Yeah.
That was
Yes.
so deep.
Yes.
Y'all give a
Mhm.
hand to the two great performance tonight, Dr. Blake, Judge, and
Everybody was great.
also, oh my God, we gotta get our Miss Mats. I mean, and who
Yes.
came and took my spot for me? Thank you, Miss Olga slash Shabbat.
Mm, mm,
And
mm.
thank you
Welcome,
to
you
my Tasha K.
welcome.
Huh? I didn't hear you. I didn't hear her. What did
I
she
was
say?
saying you welcome, you welcome.
Oh.
I just
And
had
Miss
so much to do.
Tasha
I
K.
would have been here, but my weekends is the only days I have off.
Right.
I have to
Yeah.
do everything. I would have been here yesterday and earlier today, but these Sunday I go to church. So
Right.
Yeah.
I'm just
You
glad in
guys,
real time
y'all
that
guys need to start sharing this because people need to see exactly what really happened.
mm,
But I share it on every time that you post it. I DM some of the big channels, TLA,
Mhm.
Sherelle. I mean, all the ones that had previously talked about it, and they'll put a heart, but that's it.
Yeah.
well, you know what was for you is for you, and can't nobody do nothing about it. So
Yeah,
just you're focusing on the good part because you're getting the truth out there, Sylvie. So
Yeah.
definitely.
Yeah.
it's gonna do what it do.
Yep.
But I'm just glad to know that, coming out the gate, the judge was not playing no games.
Right.
He
Right.
was ethical.
Because he's not trying to get reversed. He's not
Right.
trying to have a reversal on his record.
And
He wants to be affirmed if it happens
right,
to go to the appeal. He wants it affirmed.
right.
So
And he was very patient. Oh
very.
my God.
Woo woo.
He
I
seems like
I
a very good judge, very conscious and very like want to do his job the right way the first time.
Hmm.
Right.
Hmm.
And that's honorable. I never forget one time my judge had the case, and it was an older man who did some crazy things to his. He was a dentist. He did some things to his clients in the chair while they was under, and he was like 72, and I think he was given like 20 years, and he was like, "But judge, I'm 72," and the judge was like, "Well, just do what you can, just." he like, yeah, I mean, he was like, so yeah, just do what you can. Like, yeah, you'll probably die, but just do what you can.
Wow.
StreamYard doesn't like me anymore. It done kicked me out twice now.
Oh no.
Ooh.
The good thing is now see you're posting to catch the fall. Okay. Yeah, so
Yeah, I
hopefully.
just wish people would. These people, they don't want to support Sylvia and get the transcripts and read them. Long as Sylvia had it out there free for stuff, then they all for that.
Yeah,
Yeah.
they always knocking on the door and then I'm giving it to them.
Stand up for hours and then come back and say your whole doggone.
Yeah. And I'm glad.
But
I'm
it's
kind of glad that you are not putting it on the screen now.
Oh,
Because
people
I
were
think
asking me to put it on the screen. I was like, no.
Yep, because they would have really started pulling that and then, doing their own thing.
I was gonna say you know what though, Sylvia? What we did learn from this transcript is that TK's videos were made pre-hand and then something ignited the search. I mean, for like R. Kelly's videos, she said she had already posted them. They had been out there and then they went viral because of the documentary. So, I mean, these videos are out there. No telling what will happen in the future. Let's pray on it and they're going to go viral. People are going to want to know.
And if anything, because I presume that there's probably not a lot of truth in those videos. So, if
Good
anything,
night, Rabbit. I'm sorry.
If anything, that'll come. She'll be on
Yeah.
them videos in a minute.
Right. And maybe you should start hashtagging a lot of people and adding.
I do. I have, well, y'all.
In the
Y'all know
description,
I'm like, Mel hasn't taught me how to do that.
in the video description and stuff.
Sylvie.
No, I'm gonna blame Mel.
Okay.
Yeah, because it's really interesting.
Yeah,
Well-
y'all made me feel like I was back in court. I had to stop. That's why I wanted to listen instead of having to read. I was like, I'm gonna listen to this because this is real good stuff.
It's definitely getting juicy. It's definitely it got juicy.
Mm-hmm.
Do you notice, like, I said it. That's what TK kept on doing. Like,
Right.
Mm-hmm.
I thought her vocabulary was, better and bigger than that.
Excuse me, I'm gonna have to get off because I want to go watch that show. It comes back on at 11:00.
Okay.
The real.
Okay.
I'm gonna do it
All
on
right.
the other channel. All right, I'm gonna go put it on the other channels because then I can go delete it.
Okay.
All
So
right.
guys, y'all can follow me
with y'all
at the
tonight.
time if you want to. Huh?
That's a great time with y'all tonight.
It was really
All right.
wonderful.
Y'all. Thank you, Dr. Sherry.
Yes,
Alana.
thank you so much.
Thank
I hope
you.
she just comes back to hang with us.
Come back, Dr. Sherry.
Dr.
Alana.
Sherry, come back.
Sylvia,
I'm right here.
Sylvia, you going to your other
I'm
channel?
right here, sweetheart.
Yes, I want you to come back with
I'm
us
right
and
here.
read another part somewhere.
Let's go.
Okay.
Sylvia, you going to your other page?
Ready.
Yeah, I am. All right, everybody. Good night. Thank you, everybody.
Are you
See
going?
y'all.
Sylvia, you going to your other page?
Good night. Y'all have a good night.
Good
Yes,
night.
she
Yeah,
said that. Uh-huh.
Which page is she going to?
my second page.
Oh, okay. Okay, I'm gonna be over there.
All right.
Okay, bye bye.
Good night,
blessed.
everybody. Thank you, everybody. Good
All
night.
right.
Good night, y'all.
Good night.
Good night.